Hey guys, and welcome to today's video. Today we have two sovereign citizens in Kansas going head-to-head with two Kansas judges who have zero interest in drinking the sovereign citizen Kool-Aid, no matter how much it tastes like thermometer juice. Also, it's Thanksgiving. So I want to take a brief moment to say thank you. I'm approaching 200,000 subs, and I couldn't have done it without the support of each and every one of you, and for that I'm truly thankful. So let's begin.
Your case. This is just the time just to let you know what your charges are. Did you get a copy of the charges against you?
Of course not. I haven't even been found guilty on the sanction, the write-up while I'm in here.
Well, of course you're not going to be found guilty yet.
But I mean, I don't mean to interrupt you, but that's the procedure. And I mean, we could talk to the Department of Justice about the jurisdiction of the case as well. We can take it to that extent, but you can go ahead and continue. I would like to challenge the jurisdiction on the charge. I want to state that for the records as well.
You know, you wouldn't have to apologize if you just shut up in the first place. But let me tell you something, this judge had the perfect response to this.
Will be a $7,500 cash or surety bond.
Those charges aren't even my record. For legal detainment and corpus.
Very well. The court's going to go ahead and set your bond at $7,500 for security.
Maybe he's facing the grand jury.
If you can, sounds like you can afford your own counsel, so I'll let you go ahead and see about doing that. If you can't afford it, when you get around to your next hearing, you can ask the judge to appoint counsel for you. But I've given you your next hearing date. You know what your bond is. You'll need to stay with the sheriff until such time as you are able to execute your bond.
And so we didn't address the jurisdiction issue either, right?
Well, that's not how that works. If you can afford to hire your own attorney, then your options are defend yourself or hire your own attorney. But we, the taxpayers, won't be funding your defense.
Q real quickly and see if it's something that might be in there. Well, I'm not seeing it, but yet I don't know how I could have gotten out of jail without making a bond.
And my notes do appear to suggest that that the defendant did appear in custody. To cut it to the quick, Your Honor, the state will be recommending, based off of the amount of the bond and the charges before the court, at the very least $15,000 cashier surety or no bond hold, depending on which way the court determines is appropriate. The state would also defer to the court as to whether a bench warrant or a bench bond forfeiture should be the court's order at this time.
Well, I'm going to issue a bond forfeiture, but if he didn't post the bond, then of course we can't enforce it. But I'm ordering a bond.
Well, that's one way to put it. And to be honest, I wish all judges responded to in custody sovereign citizens like this now somehow or another, and not because he paid a $7,500 cash bond to get out the jail, release him from custody, despite that he did have a court date on November 18th. So let me ask you a question, given that he's a sovereign citizen who doesn't believe the courts have jurisdiction, nor was he supposed to be released from jail. To begin with, do you think he actually...
License plate, I think they mean that the vehicle didn't, not the highway, but your vehicle did not have the assigned license plate properly affixed to the rear of the vehicle, showing the current registered year. And this is an unclassified misdemeanor. It is punishable by up to $2,500 in fines and a possible sentence of up to 6 months, 30 days minimum, up to 6 months, although probation is usually granted. Now, sir, did I not just have you in municipal court recently on the same charge?
Yes, and I don't understand why am I seeing again, because that would be double jeopardy. I'm saying for the same.
Sir, you haven't been tried on it.
Well, at least the court's doing something to fix the problem, issuing a bench warrant, and increasing the bond amount seems appropriate. Let's just hope the police pick him up before he commits any more sexual crimes. Now, for our next sovereign citizen, we stay in Kansas, where we have a sovcit who thinks he can operate in the private while driving his car on a public roadway with sovereign citizen traveler license plates.
Is my straw man? I am the man and this is the straw man. So if you're calling the straw man, I'm here to represent the straw man, but I'm able, Estrada Junior, the man, the living man.
I'm calling the living man.
So I can,
So are you going to have an attorney? Are you going to need to apply for court-appointed attorney, or will you be waiving your right and representing yourself?
no, of course, I wanted to have an attorney, but I still haven't not made my statement, which is,
Well, are you going to hire an attorney or apply for court-appointed?
I cannot afford an attorney, but I need to make my statement that
Let me get a few things worked out, sir. You're going to apply for an attorney, so you'll need to fill out an application for court-appointed attorney. And the deputy down there can give that to you. Make sure you fill that out and get that back to me before this hearing is over. Make sure you fill in all the blanks and you sign it and you date it where it says to, because I generally don't consider those if they're not thoroughly completed. And then you call back to my assistant, Missy, later in the week to see if one is appointed and who that will be. Do you need Missy's number, or did you take it down earlier from the other hearings?
no, I don't have.
All right, Missy, do you want to give him your number?
620-583-8155.
And then Missy, when is his next court date?
Well, I haven't explained my position.
Sir, we're not going to have a trial today. You're going to need to talk to your attorney before you have a trial. So Missy, when is his trial date?
I wanted to move.
Sir, please do not interrupt. Missy, when is his, and we won't set it directly for, do you want to set it directly for trial, or do you want to set it for a status so I can check in with you after you talk to your attorney?
I don't know what the status means.
Well, let's set it for a status, Missy, or control.
November 22nd at 10.
You, sir, will need to be back here by Zoom November 22nd at 10 a.m. Are you on bond? Let me check.
Why would I need a bond?
Complaint from legal cause. There is no bond on the file, and it is an unclassified misdemeanor. So I'm not going to make you file a bond since it's an unclassified misdemeanor. If you fail to come to court, though, most likely a warrant would be issued anyway, and you'd be taken into custody. But as long as you come to court when you're told to, that's not.
With hindsight being 2020, I do know. So originally, the defendant was charged with multiple citations, with one or more of them being civil infractions, and handled by the city courts. After the prosecutor reviewed this charge in particular, he realized that was above the jurisdiction of the city courts. So he had it dismissed without prejudice and refiled it appropriately with the district courts, which is also why it's not double jeopardy.
For this, and I have the license plates, both license plates. I was not driving anything unlawful or illegal. I'm living in the private. I'm driving in the private, and so I want to move for dismissal with extreme prejudice. And also, I want to make sure that you.
All right, so we have the next court date on to the next video. Right, wrong sovereign citizens have a unique way of dragging on and on when in court, and our resident brain donor is no different.
On the date that I gave you to reappear.
I'm sorry, I didn't. It's breaking up. You said you're gonna take what up to do what?
I can take up any motions that you want to file at a later date. With the next court date, we can revisit any motions or visit any motions you want me to consider.
I appreciate it. Thank you.
You're welcome.
Being dragged on so much, and I have a hard time moving around. As you can see, I'm disabled, and I only come here once a week to the hospital to be treated, and all this court is putting a lot of stress, and I'm not able to heal properly. Why are we dragging it out so much, ma'am?
When did you get this disability? I don't remember you being unable to walk the last time I saw you.
I came in my bike is right here. I have it right here. I don't know if you can see it. But I normally use a walker in a wheelchair, but I'm using the other one because it's easier to carry in the car. It's what's it called? It's knee scooter. I have two amputations on my feet. So ambulation is very difficult. I'm having a lot of pain. In fact,
Like I said, it's not double jeopardy because there was no conclusory disposition. The prosecutor simply had it dismissed without prejudice in city court and refiled it in district court, not double jeopardy.
So you're always welcome to come down there to the courthouse like you're doing now, but you don't have to as long as you can communicate by Zoom. And remind me, what town do you live in, sir? Are you from Kansas?
yes, I'm in Howard. But even last night, when I got the letter from the sheriff, they brought it to me at 5 o'clock last night. I didn't even know.
All right, well.
So it wasn't improperly served. I got it like literally last night. We're trying to get people to come in and I don't have the time. I don't have the ability to move that fast. And so
You were just complaining a moment ago that this case wasn't moving fast enough, that we were dragging it out. So there you go. Moving too fast, you say.
Yes, but it's dragging on because it should be.
No, it shouldn't be dismissed with extreme prejudice. It should be dismissed without prejudice for lack of jurisdiction and then refiled in a court that does have proper jurisdiction, which is exactly what happened. So Judge Webster gave him a new court date and appointed him a public defender. How do you think that worked out?
I need to withdraw from this case.
Your Honor, Mr. Estrada has filed pro se, I do believe. Well, I know it was pro se filing.
Well, I do notice he's taken a number of filings in his own right without going through counsel. Mr. Estrada, you come back to my recollection, we've met in city court, correct?
Yes.
And now this is that tag and suspended license?
No.
Just a tag issue, Your Honor.
Just the tag, Your Honor.
All right.
I believe Mr. Paul is requesting to withdraw based upon the essentially sovereign type citizen claim filed by Mr. Abel.
Well,
Mr. Estrada, excuse me.
And also there's been a total breakdown in communications, Judge. He files his own motions. I cannot represent him.
He's okay. All right, Mr. Estrada, you were appointed an attorney. Apparently at one point you wanted one, or maybe we gave you one and you didn't want one.
No, that's not it.
Excuse me?
I'm sorry, that's not it. He's not, Richard Paul is not seeking my interest. And I put everything in an affidavit. He's not representing me. He's actually judging me before.
Unfortunately, that's not how this works. You don't get to choose who does and does not represent you, especially when your arguments are he didn't listen to my paperwork. And I don't agree with his legal strategy. Nonetheless, Judge Webster does release the current public defender and eventually appoints him another one.
The last case you have on the docket?
Until 11, Judge. I have an 11, so I'm just going to mute myself and.
That'd be fine. All right. Now, I think you are going to have the same problem with any other attorney that you had with Mr. Paul. Mr. Paul, from this court's experience over the years, is a very competent, diligent attorney. Now, sometimes attorneys have to tell you their opinion of what's going to happen. And you may or may not agree with their opinion, but you do still want an attorney.
I do. I do need an attorney because I don't know how to defend myself with this court. And also I have a thread of the communications that you can see it. And I'm not getting represented correctly. I'm sure he's a competent attorney, but I proceeded to give all my information, all my laws, and he
all
doesn't.
Of your what? Your laws?
The laws, the Constitution.
Your Honor,
So,
Your Honor, could I say something, please? Mr. Estrada, every attorney who the court can appoint to represent you, one, I don't want to see, and I'm sure the judge is the same way, I don't want to see any kind of communication thread between yourself and Mr. Paul, because there could be confidential, well, I'm sure there's confidential and privileged information within that, and you shouldn't be disclosing that to me. That's between you and any attorney you so choose to have represent you. But I believe most attorneys, or all attorneys that the court has available to appoint to you, they are sworn to uphold the Constitution of the United States and the state of Kansas, and not what you filed. That's the attorneys didn't go to your law school, which is kind of what you've set forth. So that's the issue the court's talking about when you're claiming a sovereign citizen. We don't have an attorney who's, I guess, registered to under your rules and laws as you see them. So that's the problem you're going to be running into as far as the attorneys the court has to appoint to you. I said that correctly, Your Honor.
Thank you, Mr. Dean.
I like to say that I'm not a sovereign citizen. I'm just an American, and I'm just being constitutional.
Not constitutional law, you know, because case law is based on previous rulings on constitutional principles. For instance, Terry v. Ohio is case law that helps define what does and does not constitute an unreasonable search. So lawyers will use that case law when arguing Fourth Amendment issues during trial. In other words, your lawyer wouldn't be a good lawyer if he wasn't researching and applying case law to your situation.
In essence.
No, I don't. I'm just presenting the law to
All right.
him, and he doesn't even read my documents that I presented, which is the law.
Did you go to law school?
No, ma'am.
He did. You know that.
Yes, I understand, but he's not being constitutional. That's what I'm saying.
But you didn't go to law school, so are you sure you know what being constitutional involves? I mean, we all can read the Constitution and understand, yes, but there's a lot involved in understanding.
That's not a very convincing yes. You can tell that he's at least moderately familiar with the case and the defendant, and that he's 100% not excited to have to listen to him talk about how he wasn't in commerce, and how the courts don't have jurisdiction to begin with, and whether this is an admiralty maritime or common law court. But a job's a job, and informing him that his Narnian law is irrelevant and won't be used as. His defense is part of the job.
Right, and let me ask you this. You are wanting a trial on this illegal display of a license plate or failure to display, right?
Well, no, I like to address. I'd like to first, if we possible, we can a motion to dismiss with the street.
We're not going to do that today. All right, I am going to one more time appoint you an attorney.
Your Honor, could I make a request to the court on this matter?
Sure.
This case carries a maximum sentence of 30 days. Doesn't even have an eligibility or requirement that he be provided an attorney.
Well,
I'm just
there's potential jail time.
I would like to have if the court wants. I understand if the court wants to appoint an attorney. Absolutely, don't dispute that. That under the circumstance of the defense that's wanting to be presented, I would ask the court to appoint somebody. I get Mr. McClendon is still available.
That's just what I was thinking. He's here in town.
We set this next hearing, give sufficient time, perhaps 60 days, perhaps longer, and we just have it set for a bench trial. And if he doesn't want to cooperate with that attorney, the state would be asking for the court to proceed to trial, whether or not he can get along with the second one or not.
Well, it seems we're on the same page of thinking, counsel.
Mr. McClendon is in the waiting room.
Mr. McClendon.
I can bring him in.
Bring him in. You're in Howard. He's got an office here in Eureka.
Mr. Estrada believes in Wichita.
I thought didn't you tell me you were in Howard?
I'm in Howard.
No, my mistake. I might have been on one of the notary stamps.
Well, you let Kit Collins in. Does Kit Collins want an appointment?
Oh, no, Judge, I just let all the 11 o'clocks in.
Okay. Mr. McClendon, could you join us for a moment? were you in city court the night that Mr. Estrada, the gentleman under Motorola, had the tag violation?
Yes, Judge. You pointed me to his case.
All right, so January 3rd, we get more stupid from Mr. Estrada. Now, I have a prediction to make while he was assigned a new lawyer. I bet he and his new lawyer are going to have the same exact problems that he and his old lawyer had, and he will end up firing his new lawyer representing himself at trial and being found guilty on all charges. So if you like the video, hit the like button. If you disliked it, hit the dislike, but don't. Forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out music. Here we go.